SJC-11669, Commonwealth versus Brown.
Good morning, Your Honors. Attorney David, may it please the court, Attorney David Mirsky for Timothy Brown. I would first just like to address the Commonwealth's motion to transmit Exhibit 164. I looked at that. That's part of that's a redacted interrogation of what was very long, 2 days. And I looked at this on the redacted on Wednesday, and in my opinion, the Commonwealth's conclusion that the defendant conceded that he believed they were going to use his gun for another robbery before they obtained the gun, either he says by somebody being told they could take it from under the bed, that he says on this tape, he was talking about afterwards. That was a thought afterwards, and on the tape it's at 16 hours 20 minutes 14 seconds to 16 hours 20 minutes 55. And if you look before that, if you listen before that, you can hear where the officer's questioning him, and there is confusion because this officer is asking a lot of compound questions, a lot of challenging, aggressive questions, and often telling Mr. Brown that he's lying, and even about how tall he says he is. And
this is a trial exhibit, right?
Yes, it is, and it's been. There's a motion pending to transmit it, and I'm just saying I think the court should look at that.
Okay.
The court may want that transcribed also just for convenience, but I would also say that you can't just look at a transcript because the officer talks over.
Pursuant to our duty under Rule 33, under the statute, we'll listen to the DVD.
Thank you.
Watch it, rather.
And I think it's important in terms of even if the court were to find that there was a concession, which I don't think there is, I think that we need to keep in mind Zanetti talking about aiding and abetting did not change the law of what's required to prove guilt. That the level of culpability has to be that aiding and abetting is a term of art. It's not just mere acquiescence in some way that helped in some proximate cause or asserted proximate cause. It's having the intent on the level of culpability of a principle and that's why most of the cases that you would find are going to either involve the person's present on the scene, and anything they're doing, they're knowing that they're in the middle of a crime being committed, and all the inferences that come from being there and having gone there are innate.
Pre or post Zanetti, was it not sufficient to show that you are guilty of an armed robbery if somebody says, I'm going to go rob somebody, I need a gun, and he either says, sure, here's a gun, as one person, I guess, testified, the other person said, he said, come on, you're going to get it back, and he said, okay, it's under the bed, or something like that. And then we need hoodies because we don't want to be seen, and I'll lend you some hoodies. So would that not be sufficient to show aiding and abetting?
Not in this case, Your Honor, because in this case, we have, first of all, you can parse out particular facts post hoc, okay, and even in the closing argument, as was done improperly here, I believe. But what you have here is people meeting in a bathroom, excluding my client's not in there. You have a person asked to come in the bathroom who ends up being one of the people that allegedly went to the scene. So that's not my client. You have another person asked to be the driver and told they're going to get some benefit for it. That's not my client. My client's not doing any of those things.
The discussion, I mean, we look at this in the light most favorable to the Commonwealth, correct?
Yes.
And there's an open discussion about robbing these two purported drug dealers that your client is present for, correct?
Well, no, there's not. There's vague evidence. There's evidence, and the evidence that's principally relied on by the Commonwealth, and especially noted in the Commonwealth's brief, is the prior incident that occurred where my client was not involved in.
But your client's in a car and they robbed two women who were walking down the street.
But he's not present for that, and he's not asked to do that, and he's not a participant. He's not involved in that. So it's guilt by association. He's merely present.
But he wasn't charged with that crime.
Right, and that's.
But would that not reflect on his knowledge when they say we're going to do an armed robbery, that these are folks who actually really do armed robbery?
They don't say exactly what they're going to do. They go out and do something. But the point is that what we have, if you look at the specifics that are conceded and part of the Commonwealth's evidence.
Why else do they need hoodies and a gun if they're not going to go rob someone?
Your Honor, I think it's too vague, and I think you're not showing the intent. What you are showing is that my client is merely acquiescing. You are showing that, but you're not showing that he has the intent to rob somebody or to get that he's planning.
What other activity takes place when you have hoodies to disguise yourself in a firearm? What else are they doing?
Your Honor, that the way that assertion comes in here is not the way that it came in at trial. What the principal argument was that the Commonwealth is saying that the apartment was small, and so he had to have heard everything. Okay, and there's noise going on in there, but that's not specific evidence, and that's not doesn't meet the in re Winship standard. That doesn't require proof the Commonwealth to meet its burden. It's too saying that he was in the car where these two people went off to another location and did something that he's not part of, and he is not supposed to be part of it, and he's a merely present junior individual that's with some people that appear to possibly be very bad, but he is not part of what they're doing. And that the Zanetti, the aiding and abetting is a term of art. It's not meant to say if you did anything and it happened to be used by somebody else in a bad way, that you're guilty as a principal would be. You have to have that intent. You have to be part of that. And if you look at the cases don't fit what happened here, the cases that the Commonwealth's raised. And the case that I think is closest, but it's going to be hard to find a case about where there's not enough evidence. I mean, that's going to be all different types of situations. But the Reveron case, they didn't even find probable cause in that case, and I would recommend that, looking at that. If you mix that, and I'd like to blend some of these arguments go together, the issues go together, because there was the absence, because you need, if you're not present for a joint venture, you need to have some kind of extra intent shown And that is illustrated in the Vega case where they asserted the person was a mastermind. And they're not saying, there's no way that.
Isn't it shared intent to accomplish the crime? It's the intent, it's the armed robbery intent, right?
When you're not present.
I'm not aware of what extra intent means other than shared intent to commit the principal crime.
Well, I'm talking about the cases.
No, I understand what you're saying, that if there's evidence that someone's the so-called mastermind and they send their henchmen, I guess, to complete the picture out to do a crime, that's one thing. But here the Commonwealth's allegation is that Mr. Brown supplied instruments so that they could accomplish the crime. And you're saying that's insufficient?
Well, Your Honor, you added a word, so they could accomplish the crime, and that's not what I'm saying. He did not do that.
I guess we're going in circles.
Right, so I mean, clearly, when we go over the record, I mean, I think there's no dispute that if the evidence does not support the view that he knew that they were using the gun and to be using the hoodies for the purpose of committing a robbery, then you'll win. But you're saying that the evidence is not sufficient to permit a reasonable jury to find that?
I'm saying that when the person, and this is from Commonwealth versus Reveron, that is an appeals court case. This court can give them, clarify it or change it, but I don't agree with what's being said about joint venture. It doesn't mean, the fact that Zanetti came along, it doesn't mean you can say someone's an aider and abettor, and it just means, okay, they did one little thing in it, and because that might be in a chain of events that led to the result that they had the intent. That's not what it means. You need to show that if you're present, you have additional inferences and facts of the presence that show the intent. Also, if you're nearby to render aid, that is a clear presence. If you're not present at all, and something you did is involved with the people who did the criminal conduct, you've got to show either that you've got to show that you counseled, hired, or otherwise procured, that you wanted this to happen, you instigated it, you directed it, you caused it, you pushed it forward, and you don't have that evidence here.
So you're saying that when you're not present at the crime, you need to have evidence that he was involved in planning it, as opposed to providing the means to commit it?
It doesn't have to only be planning, but it has to be something more like demanding that it happen, saying, I want this to happen, pushing it to happen, asserting that we've got to have this happen.
Okay, so you're saying then that if the evidence is, we're going to be holding up two big guys, one of whom I think is a bouncer, we only have one gun, I better have a second gun, can I borrow your gun? Yes, that would not be sufficient because he was not involved in planning it.
No, Your Honor, I'm not only saying that it only has to be planning. I'm saying it has to be counseling, hiring, or otherwise procuring. So you're like a principal.
In my example, if that's how the evidence indeed plays out, you're saying that would not be sufficient.
Right.
And do you have any case that says that?
Yes, Reveron. Commonwealth versus Reveron's quoting Commonwealth versus Tavares, quoting Commonwealth versus Amaral. It's in my brief on page 29.
If I can turn you to the issue of felony murder, have you found any case anywhere in any state in which a person cannot be found guilty of felony murder where they, taking your example, did not plan the crime and were not present at the crime?
Your Honor, I think the argument is based on the Michigan case, and what I'm saying, and I think this court in the Matchett case acknowledged that there's a problem if a person can be found guilty without actually having the intent, and if you're going to find a substitute way to find that intent other than for first-degree murder, other than what we have already, that you're getting further away from actually convicting people for what they're guilty of and what they've done. And that is a philosophical idea, but it's also something that relates to a lot of things that are going on right here in this case, in the way that Zanetti is being talked about as if it just means anything. It doesn't mean something specific. You have to be like a principal. You have to be as culpable as a principal. Okay, that's what I'm saying, number one. Number two, you can't argue that the person was planned and executed when you know he didn't. There's no evidence he did that. He didn't do that. He did not plan and execute, and you're telling the jury this, and we can hear ad infinitum, oh, that's an inference that can be drawn from the facts. That's not a reasonable inference, and that is denying due process, because we're getting these two things together. We're getting further and further away from having specific definable conduct that constitutes a crime. And the more discretion, the more you remove that, and the more you make it attenuated acts can become put you guilty of the final incident.
You're saying that it's not a definable crime and it's a constitutional deprivation, that your client, in a light most favorable to the Commonwealth, supplies a means to disguise oneself to robbers and gives them a gun, and your client doesn't know that's a crime?
No, Your Honor. I'm saying that you don't have that here.
I guess we'll go
Okay,
we'll look at the evidence.
And I'm also saying that to use joint venture and felony murder, and to use argument the way this Commonwealth has used it, which I think is improper, but you're making leaps of inferences further away from facts, and it's going to, and it violates due process, and that's what Jackson versus Virginia is all about. If you don't have definable crimes, you can convict anybody of anything. You can punish people for what you don't like, and not be specifically what they did, and the jury doesn't have to, the Commonwealth doesn't have to produce specific evidence. And also, if you can lie about it and what the facts are, saying that he's planning and executing when obviously he's not, you're really far afield. But I feel that there's a need for clarification that what Zanetti said, that the law did not change, and it's not that anything is now joint venture. It's that you can be guilty if you have the culpability of a principal. You can be guilty as the principal, and we don't have to say which is which, because there was confusion about the way that was applied. But it doesn't mean that there's a lesser standard. And I've heard a prosecutor in another previous case say, "Well, it's just like anything. It's just you just have to show this, and that. You know, vague things. You don't have to show anything specific anymore because of Zanetti." That's not true. It's not true because Zanetti doesn't say that, and the due process clause doesn't allow it, and Winship doesn't allow it.
Okay, thank you.
Thank you.
Ms. Johnson, good morning.
May it please the court, good morning. My name is Melissa Johnsen. I'm an assistant DA in Middlesex here on behalf of the Commonwealth. And I'd like to start the discussion with Zanetti. As my brother had pointed out, the Reveron case, there actually is a footnote there that made it very easy to understand what happened and what happened with the landscape of aiding and abetting since Zanetti. It really didn't change the underlying substantive law here. What it did is a recognition of joint venture is not so much defining a perimeter around a crime scene. If you're outside the door, no. If you're inside the room, yes. What it said is we need to look here. What's inside the defendant's head? That's what defines culpability. What's inside his head? Does he have the intent that his venturers do, the intent, specific intent to do that crime? And does he have the knowledge of what they're doing, the knowledgeable participation in that as defined by certain steps that he may have taken to make that venture a success?
That
Yes.
plus conduct, correct?
Yes, the knowing participation I see as the participation part. There does have to be some kind of step to make that venture a success, and I think that was referred to in the Raposo case, kind of illustrated that aspect of it. So it is knowing participation, and it is shared intent. And I will point out that when a judge, and this judge did instruct word for word Zanetti, it does caution the jury, look, you can't just convict someone on mere association or mere knowledge of the crime, or even that the guy didn't take any steps to prevent the crime. It really puts the brakes on that minimal evidence and asks the jury to affirmatively look for signs that this particular defendant shared that intent, that this defendant knew what was going to happen, that this defendant took some steps to actually make it happen. I know there are words in that instruction that talk about hiring and counseling, which are, you know, maybe more legalistic terms, but what the defendant did here falls into that category. And looking at it in the light most favorable of the Commonwealth, starting at 8:45 that evening, we have him present during an armed robbery. Did he actually see it happen? We don't know that, but we do know that that Hernandez and Hill came back to the car. And eventually back to his apartment with the proceeds, with the purses. Hernandez stowed his gun in the defendant's refrigerator, above his refrigerator. So he fully knew what they had done. He actually even gave Hill a hoodie so that Hill could go to the ATM and try to get some money.
Before the robbery, was the evidence that there was a firearm taken out of the trunk? Was the defendant aware that the two robbers of the women were armed?
Yes, I believe that there was testimony from Hill that actually he had gone to the trunk, he had taken the gun out, robbed the women, and came back. He actually had the purses and the gun in his lap as he came back to the car, and then they drove around the corner again, and then he put those items in the trunk. So he knew what was going on.
Defendants in the back seat?
Yes, the defendant and Dobie were in the back seat. But even if he didn't know what was going on exactly at that moment of the armed robbery, he certainly knew before the next venture, because those people came back to his apartment. They started rummaging through the purses. The defendant gave Hill his hoodie so he could go to the ATM and see if he could get anything. He gets nothing. So then they start plotting their next venture. And here's where the McDougal cousins come in. They start talking about it. Now, I know my brother mentioned that maybe someone was in the bathroom, someone was not. There's testimony here that actually this is a tiny, cramped apartment, and they were all gathered in the kitchenette. And in the light most favorable to the Commonwealth, one can infer the defendant knew exactly what they were talking about. And I do urge, like my brother, for your honors to look at his statement, because he does refer to that conversation. And he does refer to the earlier armed robbery, and he talks about that's what gave him reason to pause and think they're planning another venture. And whether you take that to mean he didn't think about it till after they left or he thought about it before, either way, I think that in the light most favorable of the Commonwealth, he knew what was going on. So we have that statement. And then what happens here, and as it's described, there were 3 men that testified on behalf of the Commonwealth that were present there. As it's described, he gives these his co-venturers the hoodies so they can disguise themselves. So he knows in his mind they're up to no good. They're about to commit another robbery. And then there's discussion of the gun, asking the defendant to give his gun. And this is key here because they've talked about, and Karan, one of the cousins, has talked about the fact that these are pretty big guys here. They work at a bar. So he knows, not only is there someone present in this house that they're about to rob, but they are more than one guy, and that they're pretty big guys. So that second gun now becomes key, and the defendant knows it, and he gives that gun to Jamal. So those 2 guns all of a sudden become the impetus for how this confrontation ends up in the death of the Delgado brothers. Because if you look at what actually happens, Hernandez and Jamal go inside with the gun. Caron and Silva stay outside. They're not going in there. They know that there's at least one pretty big guy in there. So they go in. So it's that second gun here that is the key to why this ended the way that it did. And so I would argue, in the light most favorable of the Commonwealth, we do have evidence here of a joint venture of aiding and abetting.
Can we turn to felony murder? Have we had any case in this Commonwealth in which somebody who did not plan the crime and was not simply a getaway driver was found guilty of felony murder without having gone to the scene of the crime?
Well, if there was, I probably would have put it in my brief. I'm not aware of any, although I would just clarify when you say hasn't planned the crime, I would argue, and it was put forth that this defendant was involved in the plotting of this crime. So,
Plotting of the crime? What evidence is there that he was involved in more than the provision of the hoodies and of a gun?
and I would argue, Your Honor, that is one of the keys to how this crime is a success.
Well, I understand that.
He's contributing to the
understand-
success
I
of this
understand that,
crime, which
but
is what
that's-
Zanetti asked for.
No, I mean, I'm not suggesting that that would not be enough to be
Yes.
aiding and abetting. But are
Yes.
you saying that that's enough to show it's planning? Or it's,
I think implicit planning, yes. We are going to plan because we need the second gun. We need some way to hide ourselves. He may not say explicitly to his co-venturers, let's plan a crime. What are the steps to it? But one can infer this is implicit planning going on. We are providing for the fact that someone may identify you. We are providing for the fact that you are going to be confronted by at least one or two pretty big guys. So
I
in
guess
that sense,
if we don't accept that that's planning and that the defendant's culpable because he supplied the instruments to commit the crime with a shared intent, the answer to the chief's question is that you can find no cases where someone did all that and stayed home.
no, Your Honor. No, there's not.
let's discuss 33E. Ariel, Jamal, and Karan go to trial. Jamal, who I think was the person who he delivered the gun to, was found not guilty, as is Karan. The driver gets 3 years. Silva gets 7 and 7 in a day, with cooperation, I gather.
Yes.
And Hill, who I don't think there's any claim was involved in the murder, but was involved in the purse robbery, gets 3 years probation. Should it concern us that the person who did, let's accept your argument that he did what he did, and he did what he did knowing it would be an armed robbery, is the person who gets life without parole in this context?
Well, I understand what you're asking, Your Honor, and I certainly would never have imagined that everything would shake out the way that it did in this case. As you can see from the transcript, up until the day of trial, we had offered this defendant a similar sentence as Silva, the getaway driver, 7 years, followed by probation, had he acknowledged his responsibility and the key role that he played in the death of these two brothers. And we thought that was a fair and just disposition had he acknowledged that. But that didn't happen, and we pressed forward with what the evidence and the law dictated. And I hope that I have persuaded Your Honors that the law and the evidence does dictate the result here. I think what you're asking maybe is this consonant with justice, which is another piece of the puzzle, and that's a more nuanced question. It's more difficult to answer, and I think I would just say a couple of things about that. You know, this is the kind of case that certainly keeps the prosecutor up at night. I'll be candid with this court, but when it comes down to it, I just come back to a couple of things, and that is, number one, that second gun really did play a key role in what happened to the brothers here. I don't think without it we would be here today, and I think the defendant knew that before he gave it to them. And the other thing is, this is not some kind of unavoidable tragedy, and the Delgado brothers are not collateral damage. This was a murder because those defendants went in there, knew exactly what they were doing, and did it with such disregard for the sanctity of the lives in that house. So in that sense, you know, the law of our Commonwealth, that is a murder. And so I can't really get past that when I try to think about what's consonant with justice here. That, to me, means that the verdict here was fair and just. And I hope that the court understands that from our perspective. If there are any further questions, I rest on my brief. Thank you.
Court, all rise.